Good afternoon. This is Claude Dixon, Acting Senior Advisor for the Office of Recap, and we're here for the second Q&A session on the RAD Fair Housing, Civil Rights, and Relocation Notice. We have a number of subject matter experts around the table here, and I'm going to let them introduce themselves.
Hi, my name is Brian O'Neill. I'm with CPD, Community Planning and Development, and I address Uniform Relocation Act issues.
Hi, this is Celia Carpentier. I'm with the Office of Fair Housing and Equal Opportunity.
Hi, my name is Tiffany Johnson, and I work in Public and Indian Housing under the Voucher Policy Office.
Hello, my name is Sheba Cousins, and I work in the Office of Public Housing.
So I am going to turn the mic over to Daniel Gordon, who will tell you how you can ask questions for this. What we're going to do is we've received several questions in advance. We're going to answer those first, and then we're going to open it up to questions that people want to ask us. Dan?
Hi, everyone. So there are a couple different ways that you can ask questions. The preferred method is to raise your hand, and that we will call on you. Raising hands is a little better because it makes for more interactive broadcast and allows you to ask a follow-up question if we don't quite get to what you're asking about on the first try. So we suggest raising your hand, but the catch with that is that it's a lot easier if you call into us rather than have it on your computer, because some people's computers, microphones are not always turned on. So if you're calling into us, then you'll be able to get through to us for sure. You can also type in your questions using the question feature on the webinar. And I'm going to do my best to get your names right, but I apologize in advance if I don't. So with that, I think we can get started.
Okay. I'm going to start with the first question that we received from one of the people who registered for this Q&A. How should required noticing under Section 6.6 of the new notice be implemented if a PHA already has sites with active CHAPs? I think there's been a lot of confusion over the implementation of the new notice. The way we approach it is to sort of take a snapshot of the project as of the date that the notice was issued, which was November 10. So, for example, if you had submitted your financing plan by November 10th, we are not going to ask you to go back and issue RINs because your project has gone beyond the point where a RIN would be required. What we would expect at that point is that you had issued GINs under the old notice, because that was a notice that would have been effective at the time that the first notice to the tenants should have been sent. So Section 6.6 deals with relocation notices. So under the old notice, with HUD approval, you could ask for a notice of intent, to issue a notice of intent to acquire. Under the new notice, you don't have to ask for HUD permission to do that. But if you were beyond that point, where say you were at financing plan or at RCC, and you wanted to issue your notice of intent to acquire and issue your relocation notices prior to RCC, that's what you would have had to have done under the old notice, which would have been in effect at the time you wanted to take that action, perhaps. So it all depends on where your deal was at the time the notice was issued. If you're past the point where the requirement would have affected you, you're not expected to comply with the new requirements in the new notice. And I hope that answers the question. Brian, the next question.
Okay, this was a question that was submitted to the website, and I'm going to read it to you. It says, I am particularly interested in the relocation similarities and differences from other programs. An example is Section 18. That's a really good question, and it's not that easy, let's say. So for RAD, think about RAD has its own unique relocation requirements, and they are unique. And the reason why I say that, those requirements aren't necessarily applicable to other HUD programs and projects. So the requirements in the notice, you really need to, in the RAD, Fair Housing and Relocation Notice, as we said in the prior notice, you need to keep those only applicable to covered RAD projects. So RAD has its own relocation requirements. However, there are some some statutory requirements that could apply if there's acquisition, rehab, or demo, which would be the Uniform Act, Uniform Relocation Assistance and Real Property Acquisition Policies Act. So that could have application to RAD projects. If home or CDBG funding is used in connection with the RAD undertaking, there could be another set of statutory relocation and other requirements that pertain to the undertaking, known as Section 104D of the HCD Act of 1974, I believe. Section 18, for Section 18 demo dispo projects, Section 18 has a statutory exemption from Uniform Act requirements. However, it has its own relocation requirements. However, if CDBG or home funds are used, Section 104D could apply. So you get my drift. It can be very complex and it can be very confusing. So just so you know, there are statutory requirements out there. There are program-related requirements. So you really need to know what's in play in whatever undertaking you have. So that probably doesn't answer the question, but it might be good advice.
And the RAD, Fair Housing Relocation Notice, is very much of a hybrid in terms of a mix of RAD program requirements and URA requirements.
Yeah, that's right, Claude. So RAD has kind of, let's say, adopted some Uniform Act-like requirements within the context of being a RAD relocation requirement.
Okay. And I'm going to jump back to the question I originally answered. I want to give another example of how it works. Let's say that your deal is has not yet gone to RCC, but you find that you want to relocate tenants prior to closing, but you haven't issued any relocation notices. In that instance, your issuance of relocation notices would be governed by the new notice. So you could, without asking HUD for permission, issue your notice of intent to acquire as long as you were, I believe, approximately 90 days before you anticipate going to RCC, and you could issue your relocation notices at the same time. That's assuming, of course, that your transaction involves an acquisition, and you would just follow right through with the new notice requirements. It's where things are different is only when the time period for issuing a specific notice has passed. So going back to my original example, if you're past the 2 initial tenant meetings, we would have expected that you issued your GIN according to the old notice, but we would not expect you to go back and issue the RIN because the RIN was not in effect at the time that you needed to issue your notice. Hopefully that explains things.
Yeah, and it seems to be a lot of there. This is like a question that keeps arising. So possibly maybe we could do an FAQ.
Yeah.
Or something that might be beneficial to do an FAQ on this.
Yeah.
But thank you, Claude.
Okay. And then the next 2 questions. Tiffany.
Hi, this is Tiffany Johnson from the voucher office. One of the questions that we received is, a Section 8 project-based family is relocating all tenants due to a rehabilitation with LIHTC. Are this company, who's in the company in charge of the relocation, do they have the right to ask for legal status of the resident? We want to remind you that we do not want to violate any fair housing provisions in the transfer or relocation of families. What you are able to ask is that everybody in the household is on the family composition, and that's done on an annual or biannual basis, indicating the family members, their ages, and Social Security numbers. So those are permissible questions to ask, but we don't want to get into legal status for citizenship or anything like that. So just be careful and mindful when you're relocating families. The second question that we received was, residents which are not in good standing and do not have a payment plan have been placed in court. Are they entitled to be relocated before their court case is heard? I think this question needs to be broken down twofold. So first, we want to make sure that when you are transferring families from public housing to the voucher program, that when you're signing a new lease with them, that if they owe monies, if there is a payment plan in place, that you are making sure to add in an exhibit or a rider or something, an addendum that outlines that, because these are new leases and they are new tenants. They basically, you know, sort of everything that happened in their public housing portfolio may or may not be transferred over. And monies owed is one of these sort of issues where you need to be explicit. And especially when you're going to court, you want to make sure that your documentation is all in order. So adding that addendum or rider is important. So then once you've gone to court or have a date set on the calendar, that doesn't recuse you as the housing authority of your obligation to relocate this family. The family status won't prevent them from being able to be relocated. But the reality is they can be evicted from their temporary housing for failing to comply with their family obligations, which are clear under the voucher program. So, you know, it's very important that you get the addendum in the first place, and on the second place that you remember that they have an obligation to be moved, but it doesn't prevent them from being evicted, either in the temporary housing situation or once they finally moved into their voucher unit. And make sure that you make any amendments to your admin plan on special procedures that you would be doing around it.
Okay, thank you, Tiffany. We'll open the questions, open it up for questions.
Okay. So we have one comment that only see the welcome slide, but this call is about your questions, so that's the only slide that we have up. So next we have a question from Jessica Casella. Is it possible to get information about which PHAs have requested by the deadline to be guided by the prior RAD relocation notice, perhaps on the RAD resource desk?
Yeah, it's not on there. I can tell you that to date, no one has requested to be guided by the past RAD notice. And I think the answer is pretty straightforward. The new notice fills in a lot of holes answers a lot of questions that were not addressed by the old notice. And the new notice also streamlines the procedures and reduces the number of requests that have to be made to HUD to take actions. So, for example, on the prior notice, any move prior to any relocations prior to closing required HUD approval. Now, most of those early relocations happen automatically, assuming that you've taken the appropriate action. So it's a much more streamlined process. So we haven't had anyone request to be governed by the old notice. And we've only had one question about it. And once they understood how we were applying the new notice, they were no longer interested in being under the old notice.
Okay, Michael Duarte, looks like you have a hand raised and have typed in a question. Actually, Jessica has asked a follow-up question, so let's close that loop. Is HUD considering issuing similar or separate guidance for RAD Component 2 properties? Such guidance would be extremely helpful for common issues.
That I honestly don't know. As you know, the new notice only applies to Component 1. I don't know what HUD's plans are with regard to issuing guidance for Component 2. But if I get any information, we will post it on the RAD resource desk.
Okay, great. So yeah, so Michael Duarte has typed in a question and also has his hand raised. Michael, I'm going to unmute your line and let you. You're on the line, Michael.
Hi.
Okay, there's some issues with the line there, so I'm just going to read the question. How can a family be evicted from a temporary unit? We have had issues with our court filings that prevent us from going through with the eviction.
So this is Tiffany Johnson again. I just want to reiterate that these are things that are possible, but you have to outline them in your administrative plan, and you would have had to work with your legal counsel to basically build a file. So if the issues pre-existed, the family moving into the temporary housing, then, you know, theoretically you should be able to make a case. This isn't a legal Q&A, so I just want to make sure, and we don't have any HUD attorneys here. So I hope that answered your question, but you're welcome to email us if you have some follow-ups that we can shoot up the line.
Yeah, I would only add that, you know, public housing tenants remain public housing tenants until the RAD conversion, so that they and the PHAs would be governed by PIH rules and regulations, and RAD would not impact that, this particular issue in particular.
Right.
Okay, yeah, we have one that just came in from Marilyn Baldemore. What is the maximum and minimum relocation cost for each family being entitled to?
Well, I don't think there's a maximum or minimum, but
no, there's not that we're aware of. So in the Uniform Act, the URA, it has so-called statutory replacement housing payment costs, but although there are statutory maximums, it's not really a maximum payment because as soon as the cost, for instance, of the replacement housing payment exceeds that statutory maximum, it goes into what's called last resort housing or housing of last resort, which is unlimited. So, there is no per se maximum relocation cost, and I think maybe Claude, you can address this in the new notice. There are also alternative housing options that can include not only the required relocation payment under RAD and per se the URA or 104D, there might be other payments available. I don't know if you wanted to address that.
Yeah. On this maximum minimum, I think all we can say definitively is that if a family becomes a displaced person, the gap payments would be calculated based on either 42 or 60 months, depending on whether 104D was involved. Can we go that far, Brian?
I'm just going to go back to saying that there are no maximum payments that I'm aware of. And in the case of temporary relocation, you need to do what it takes to relocate these people either permanently or temporarily, not only moving payments, but any increased housing costs. For instance, in temporary relocation, where the URA would apply, it would be any reasonable and necessary increased out-of-pocket expenses during the time of temporary relocation. So that includes moving expense payments, that includes increased rent, increased utilities, any other out-of-pocket expenses that they might have to incur during the time of temporary relocation while you're rehabbing the property or even demoing the property. So I don't know if you wanted to add some additional clarification to the question, but just keep in mind there are no established maximums or minimums, and just so you know, if you see a URA, a statutory maximum, that's not a real hard line maximum. That can and should be exceeded if it's required under last resort housing.
Okay. So we have a hand raised and a question from Amparo Gamazo. Amaro, I'm going to put you on the air and let you ask your question. Okay, Amparo, you're on the air. Okay, we're not getting any audio from you, Amparo, so I'm going to read the question off this that you typed in here. Do we need to issue the RIN for projects that are already pending a CHAP?
The RIN is to be issued prior to either of the first two tenant meetings, which are to take place prior to CHAP application. So if you are past the point where you are having those two tenant meetings, you should have issued a GIN, but not a RIN, because you passed the point where the RIN should have been issued. So I think this is a follow-up question.
Yes, Marilyn has asked a follow-up question. We'll go straight to that one. Is the relocation within 30 days notice to vacate the unit?
How about this bar?
Now the follow-up, the one is to clarify the GIN.
I'm at the bottom one.
Okay. The 30-day relocation notice is for temporary relocation, and tenants cannot be required to relocate to temporary units until the time period has expired, i.e. the 30 days. They can move early if the tenant wishes to move early. But again, no moves are allowed prior to RCC under any circumstances. So even if the tenant wants to move early and RCC has not been issued, the tenant cannot move under RAD.
Claude, can I just add something in there? So the question that was posed to us is the relocation within 30 days notice to vacate the unit? I'm not quite sure what that is. So for temporary relocation, there's a minimum 30 days notice to vacate, as Claude had addressed. If it's permanent relocation, or if it's temporary relocation that's anticipated to exceed 12 months, that would be 90 days notice. And then under RAD, I don't know if you want to address, there's a time period that the residents are actually provided, I believe, 30 days to make an informed decision on whether they want to accept temporary relocation or permanent relocation. So I don't know if you wanted to clarify your question, Marilyn. That might be helpful.
Yeah, temporary. When I speak of temporary relocation, that's relocation less 12 months or less. Even if you are temporarily relocating someone for more than 1 year, you have to give them a 90-day notice, because that is no longer temporary relocation as we interpret it under the RAD notice. Because under the URA, you are just permanently displaced once your relocation lasts longer than 1 year.
Right. So yeah, Marilyn, additional clarification would be helpful, and we'd be happy to help answer your question.
Marilyn has just asked another question. What are the eligible items included in relocation costs? Is that
in eligible moving costs? There are a lot of. It depends. Okay, it depends on if it's temporary. It depends on if it's permanent. You might want to have a look at the Uniform Act regulations as far as eligible moving costs for permanent moves. There's a whole list of eligible costs, but that's not an all-inclusive list. So there may be other costs that, if the agency determines that are reasonable and necessary for moving, that they should be payable. So I don't really know. So there are eligible costs, there are ineligible costs. We have a website, www.hud.gov/relocation, that has a lot of relocation-related information, regulations, HUD Handbook 1378, relocation claim forms. There's a lot of information there that might be helpful. And if you have additional questions, depending on where you're located, you could always ask your local CPD regional relocation specialist, and a contact list of those persons is also located on our website. So it's www.hud.gov/relocation.
Okay, great. We have a question here from Barb Tobin. To clarify, we have issued the GIN and the notice of non-displacement under the July notice. Moving forward, she does not think she needs to issue the RAD information notice, or the RIN. Can I issue the NOIA with or without the RIN?
Yeah, you're past the point where you would issue the RIN. You issued a GIN under the old notice, so there's no need to issue a RIN. And under the new notice, you can issue a NOIA on, as long as you expect yourself to be 90 days, as long as you reasonably expect yourself to be 90 days within 90 days prior to the RCC. I don't have the language right in front of me, but we don't want people issuing NOIAs like way in advance of RCC. So I think the notice says 90 days before you reasonably expect to go for RCC. Then you can issue the NOIA automatically.
Yeah, and this is Brian O'Neill with CPD. I just had what caught my eye in the question. I think, Barb, you had mentioned in your question that you say that you issued the notice of non-displacement. I just want to make everyone aware that HUD has determined that a notice of non-displacement is not required under RAD or for RAD programs and projects, although it is a kind of universal requirement for I'll say most HUD programs and projects. Under RAD, it's not required. So for everyone's information, a notice of non-displacement is essentially saying that, okay, here we have this project, we have the federal funding, for instance, we got a RAD funding, you're not going to be displaced, you don't have to move, or you're not going to be displaced, however, you may need to move temporarily, and you can come back. So that's not required for RAD programs and projects. And the question that I wanted to pose to you, Barb, was if you issued a notice of non-displacement, and I see you want to issue a notice of intent to acquire, are you now planning to relocate persons permanently or just temporarily, or are they going to stay in place? So if you issued a notice of non-displacement and people have to move permanently, that could be problematic for you.
Okay. All right, we have a pair of questions from Wilbert Gill. Are undocumented occupants displaced for LIHTC project entitled to relocation assistance? They've been confirmed that that's their status. There are also 3 minor children born in the United States.
Well, this is Brian O'Neill with CPD again, and I just have a question. Why are they being displaced? You know, I'm not quite sure, because if we're talking RAD, if everyone has a right to return, why are they being displaced? And the question about you know, their citizenship status or documentation being undocumented, I think we really would need to know more about the situation to address the question.
He's given a follow-up comment. This is not a RAD project.
Okay.
Yeah, we're focused. I think we're focusing mostly on RAD today. Is the idea.
And putting a RAD spin on this, the right to return would apply regardless of it being a LIHTC project. So even if you were over income for tax credit purposes, if you were legally residing in the project at the time between CHAP and the conversion, you would still have a right to return to the project.
Yeah, and my recommendation, this is Brian O'Neill with CPD again, my recommendation, Wilbert, would be to contact the responsible CPD regional relocation specialist, because if you're talking about displacement via LIHTC project, and I'm not sure what's all in play with your project, but I would recommend that you contact the responsible regional relocation specialist, and they can help you with some of those questions. You know, certain individuals do have rights. You know, what makes things complicated is, you know, you have 3 minor children. The URA generally prohibits relocation assistance to be provided to undocumented persons or to illegal aliens. That was a result of the Illegal Alien Act amendments to the URA. However, there are hardship exceptions that should be offered to situations like that. So you know, please confer with a CPD relocation specialist. They can help determine if the URA is in play and you know, what requirements you should follow. And again, our website is www.hud.gov/relocation, and you can look at the contact list.
Okay.
Next question.
Amparo Gamazo, who we had a question from earlier, you re-raised your hand, so I'm going to unmute your line and see if you have a follow-up question. Okay. Looks like we can't hear you right now, so either try and dial in using your phone, or you can type in your question. Okay.
Next question.
Okay, the next question is from Lisa Parata. If we are transferring residents directly from a public housing project to a new LIHTC PPV construction site, are there any additional requirements for the notice to vacate?
From a RAD perspective, the answer would be no. You would be required, if you are, whether it's permanent or temporary relocation, you would have to issue either your 30-day temporary relocation notice or your 90-day permanent relocation notice. RAD would not have any additional requirements in terms of notification of tenants prior to relocating them, again, assuming that you would also previously issued either the GIN under the old notice, if that's what was applicable to your deal at the time, or the RIN and possibly a GIN if you're under the new notice.
Yeah, and if this is purely a transfer of assistance to a new site, there's a new section in the new notice, specifically that deals with transfers of assistance. And I think Claude had it right with the notice requirements, but that section provides more guidance than what existed previously.
Yes, yes, because the notice now makes clear that the right to return is the right to return to the project which has the assistance. So if there was a transfer of assistance, your right to return would be to the project to which the assistance had been transferred.
Okay, it's a follow-up question. Is it a transfer of assistance under RAD? Also from Lisa.
Well, the transfer of assistance, I'm not sure I understand the question. It's a transfer of the subsidy assistance from one project to another. And the only spin that RAD puts on that is that for purposes of right to return, your right to return is to the project which has the assistance. So, for example, if you transferred assistance from project A where you're living, and let's say there's going to be temporary relocation, and assistance is being transferred to project B, when the renovations or whatever are completed, your right to return is to project B because that's the project to which the assistance has been transferred.
Okay, great. Okay, we have a hand raised from Sherry King. Sherry, you're on the line. It looks like I can't have you speak to the group. Sherry, either call in, and that'll be easier to talk, or you can type up your question, and we'll get to it. Okay. We have another question from Barb Tobin. As part of the RAD relocation, we are offering a permanent transfer to another comparable public housing unit in another building. We're also offering over-income, 60% AMI households, a moving allowance, and an additional inducement to move. Do we need to offer over-income households desiring a transfer the option to take moving allowance and additional inducement as an alternative option?
Well, per the RAD notice, the PHA or the project owner, they can identify the alternative options they'd like to offer. and we haven't outlined exactly what needs to be offered to over-income tenants. So if they choose to, they can.
Yeah, I think there are two questions in here. You may have a situation where you have public housing tenants who, upon being told about the RAD transaction, may decide that they want to remain in public housing. If that is the desire of the public housing tenant, and the PHA can accommodate them, they can be transferred to another public housing project pursuant to PIH rules and regulations. Okay. Now, if you have, say, over-income households and you're doing a LIHTC transaction and you don't want to modify your plans to accommodate over-income households, understand that the residents have an absolute right to return to the project, and that you will have to offer alternative housing options that would make the resident willing to voluntarily relinquish their right to return. And there are some instructions in the new notice as to what those alternative housing options should look like.
Right, and to clarify on the alternative housing option, so if you keep going with this, as Claude had mentioned, so you have over-income households that you don't want to change your project plans, or maybe it's too costly to do so. I don't know, but this happens frequently. But as Claude mentioned, they have an absolute right to return. So you can offer them under RAD an alternative housing option to choose permanent relocation, like voluntary permanent relocation, and waive their right to return to the property. So the one thing from CPD's perspective that I want to remind you, as part of this alternative housing option, if there's acquisition, rehab, or demolition involved in the project, that RAD has really adopted the URA standard even for voluntary relocation. So then those persons should be treated in accordance as a displaced person under the URA. So as far as a moving allowance, there was a reference to a moving allowance under the URA, which is adopted under voluntary RAD permanent relocation. There are specific moving options and requirements that are to be provided to a displaced person, and that's our expectation, is that those persons are afforded those same options and rights as a displaced person. So you couldn't necessarily just provide a moving allowance. You'd have to provide whatever options are available, and then they can choose from those options.
And any incentives that you provide to a resident to voluntarily relinquish their right to return would be over and above what they're entitled to under the URA.
Yeah, that's correct. Thank you, Claude.
And the other point I would make is that we expect that all similarly situated residents will be treated the same way. So if you have a half dozen over-income residents that you need to voluntarily relinquish their right to return, you can't offer one resident one set of incentives, and a similarly situated over-income resident another set of incentives. They should all be treated the same.
Another question from Marilyn. Can the family be relocated to non-ACC units owned by the authority temporarily or permanently and continue to receive subsidy?
Can they expand on their question? Are these families that are converting to RAD or remaining in public housing?
Okay, so Marilyn will look for some follow-up information. Okay, we have a question from Hillary Lopez. Can you offer different moving or relocation incentives to over-income tenants in RAD LIHTC transactions than to income-qualified households?
The answer is probably yes. Again, I would definitely check with your transaction manager before getting into this. But the general HUD policy is that similarly situated residents have to be treated the same way. So I would expect that whatever incentives or you offered over-income tenants would be the same across the board for that group. If you have tenants that are not over-income for LIHTC purposes, that could be another group, and I would expect that group all receive the same incentives. Where your question becomes difficult to answer is we don't have any hard and fast rules on what is similarly situated. So we sort of look at that on a case-by-case basis. So I would encourage you to submit the specific issues that you have or what you want to do to us to review prior to making the offers to the residents.
Okay. Not showing any questions right now, so we'll give you all a couple minutes to think of some more. Okay, we had a follow-up comment from Barb Tobin from one of her questions earlier. Can pull up both of them at the same time. So she's saying that in her situation, she's identifying similarly situated as 60% AMI over income.
I think for RAD purposes, we would consider similarly situated, a potentially similarly situated group as any resident who could not return to the project because they were over income. It wouldn't matter how much they were over income, just the fact that they were over income would probably constitute one group. But again, I would encourage you to submit the specific situation to HUD ahead of time to make sure that HUD is in agreement in terms of how you want to treat various groups of residents.
Okay. We have a question here from Dina Williams. So a family that is over income at my property that is converting to RAD has to be treated like a permanently displaced person under URA.
It's more than that. If the family is over income, they still have a right to return to the project. You cannot take away their right to return to the project just by considering them permanently displaced. No. RAD says the family has a right to return to the project unless they voluntarily relinquish that right. And the way that you go about exploring whether residents would voluntarily relinquish their rights would be looking at the alternative housing options section of the new notice, which gives guidance on how offers should be made to residents. But at the end of the day, they are not required to accept any offer you make to them. Any relinquishment of the right to return has to voluntary on the part of the resident.
Yeah, and Dina, this is Brian O'Neill with CPD. I think the response to your question is yes. So Dina's question, so a family that is over income at my property that is converting to RAD has to be treated like a permanently displaced person under the URA. Generally, I would say that that's correct. They have to be treated like a displaced person under the URA. And in accordance with the same regulations and the same, I guess, requirements that would apply under the URA to a displaced person. So what RAD has done for persons voluntarily accepting permanent relocation, the URA is basically the floor. So they've established that as the floor. So they're to be treated like a displaced person under the URA. And then as Claude had mentioned, there are other alternative housing options that are available that can go over and above, beyond the URA. So look at it, the URA displaced person is the floor for voluntary permanent relocation. And then I guess RAD program, the notice provides the opportunity to even go above and beyond that.
Right. But understand that the resident is not required to accept the alternative housing option. They can still say, no, I want to return to the project, at which time the PHA would have to modify their project plan. And one of the things that has not changed between the old notice and the new notice is that the resident must be given 30 days to consider the alternative housing option. And any relinquishment of the right to return has to be in writing, signed by the head of household.
Okay, we have a question here from Shamika Redding. What was the answer to the question about moving residents temporarily into housing authority owned but non-HUD property? Can the housing authority still receive subsidy for that resident?
It's my understanding that once they convert to RAD, they'll no longer receive subsidy for that tenant, but I need to get more information, so please consult with your transaction manager, and we'll post the answer to the resource desk.
Okay, great. We have another question from Hillary Lopez. Would it be your HUD RAD transaction manager or HUD field officer that would grant pre-approval of similarly situated groups?
We don't grant approval, but we would review it, and I would take it up with your HUD RAD transaction manager initially, because this is a RAD program requirement that people be treated similarly. So I would take it up with your transaction manager, and that person would know who to consult within HUD to get a response to you.
I don't see any more questions right now. Do we have any others? Any other questions to come in? Okay. We have a question here from Chris Love. For residents who choose to relocate, are they to be given another opportunity to return after a year passes if their former property has not yet finished construction? If so, how does this work?
Let me try to take that on, Claude. So, all right, so I'm assuming that you're temporarily relocating these folks. So I don't know if the whole idea is that if you anticipate that their temporary relocation is to exceed 12 months, those residents are supposed to be provided the opportunity to choose between voluntary permanent relocation up front or accepting temporary relocation for whatever duration time that may be. So, say it's 14 months that they're going to be temporarily relocated. They say, yes, I want to relocate temporarily. I want to come back to the property, right? I want to retain my right to return. So under the URA, which would generally apply in this situation, so you're paying all the increased out-of-pocket expenses incurred by that resident household during the time of temporary relocation, moving costs to and from the property. So after 12 months, the URA kicks in. So anything after a person has been relocated temporarily for longer than 12 months, they're considered actually a displaced person under the URA, okay? Not under RAD, but under the URA. So these other sets of rights kick in. So at that time, you, the agency, are supposed to provide them their rights and entitlements as a displaced person under the URA, what they would specifically be eligible for if they accepted permanent relocation under the URA. However, at that same time, you can offer that resident or resident household the choice between to remain in temporary relocation for an agreed to length of time. Maybe when maybe your construction was running over for 2 months and you needed 2 more months in temporary, that person should be provided the option of permanent relocation under the URA at the time, or to stay in temporary relocation for whatever that remaining length of time is to retain the right to return to the property and then be relocated back. Claude, do you have anything to add to that?
No, I mean, you have one of two situations where your temporary relocation is going to be more than 12 months at the beginning, at which time you would issue a permanent relocation notice at the beginning.
Right.
Or you have a situation where you issue a temporary relocation notice because you thought it would be less than 12 months. It ends up being more than 12 months. So once you go past 1 year, the URA would kick in and you would be given your rights.
Yeah, just to expand on it, some of these RAD deals that we've seen, I mean, they involve demolition. It's not like rehab. So, the temporary relocation is going to, very well exceed 12 months. So people, some persons really want to retain that right to return back to the new property. Maybe where it's located, maybe, there are the reasons for them to want to come back besides it being like a new property or a newly renovated property. So the key is when you temporarily relocate persons for an extended period of time, just be aware that as soon as that temporary relocation actually exceeds 12 months, that the URA rights as a displaced person kicks in automatically. So you, the displaced, or you, the agency, the PHA or the developer, you need to make sure that you're prepared that before that 12-month period of time hits, to be actually able to go to that resident household and provide them their rights and entitlements under the URA for an informed decision about whether they want to accept permanent relocation under the URA at that time or stay in temporary relocation for an extended period of time or an agreed upon time until the construction's finished. So, HUD is a little bit concerned about, just the follow-through on this. So, we just want to make sure that PHAs, that you all are prepared that when that temporary relocation actually exceeds 12 months, that those residents actually get their rights and entitlements, and that you all are prepared to do that.
Okay. Let's see, we're running about towards the end of our time today. How many more questions do we want to take? I see one has popped up. So, How many do we want to take? I guess.
I'll take that one.
There's
one from Hillary Lopez.
Okay, yeah, I'll read it. So yeah, we'll consider this the last call for questions if anyone has any additional ones. So just to clarify, if the relocation goes past 12 months and the tenant chooses to be permanently relocated, then they relinquish their right to return. Question.
Yes, that's my understanding. So anytime you choose permanent relocation, that you relinquish your right to return to the property under RAD. Is that correct, Claude? That doesn't mean that they couldn't maybe reapply to come back at some point, but they don't have a guaranteed right to return. That's my understanding under RAD.
Right.
Is that correct?
Right. I mean, once, yeah, I mean, you could maybe at some point in the future, pursuant to Section 8 rules and regulations, apply to be part of the, I mean, be with the project again, but that would not be part of RAD.
Yeah, I think something happened similarly with Hope 6, although Hope 6 didn't have a guaranteed right to return to the projects. When resident households were relocated permanently, they were actually relocated permanently, so they were considered displaced, but they could reapply to come back to the Hope 6 project. But I think our understanding is that anytime you accept permanent relocation, that you also relinquish your guaranteed right to return to the project.
Yes, that would be the case. And I can answer the last question quickly. This is a situation where a public housing resident chooses to remain in public housing, so the transfer would be done under public housing rules and regulations.
Yeah, in accordance with their ACOP, the PHA's ACOP, they can transfer to other public housing if the resident chooses not to participate in the RAD project.
Okay. And this is the question from Dina Williams
Yes.
that you just asked. Okay.
Okay.
Last call. Okay. Great. Well, thanks very much for tuning in, everyone. Claude, anything else to say?
We will be having a third question and answer probably, I think we said January 11th.
Mm-hmm.
But we will be sending out a RAD blast to give you more details about that third session. And it's our anticipation that will be the last Q&A on the new notice.
Okay, great. And Dylan, you're asked if it's possible to listen to the recording of the webinar later. Yes, we will post it to the resource desk, hopefully in the next day or two. Okay.
Thank you very much.